We're officially reorganized. At this point, we're going to, we've worked a long time, as everybody sitting in this room probably well knows, on the Duey application. And before we go into our discussion as to a decision, Mr. Agone has a few words that we'd like to enter into this record.
I noticed you underlined the word few.
I know you charge by the word, so.
Incidentally, since you hadn't had a practice of having a secretary, since we have a meeting and not a hearing, we don't have a court stenographer, it's incumbent upon the secretary to take notes and at your next hearing to approve those minutes so that it's part of our records.
Okay.
Good evening, everybody.
We see you.
He's on.
The bottom.
The bottom.
Yeah, the bottom.
Base.
It'll turn
Oh, there we go.
There we go.
Good evening, everybody. Because we have an awful big record and the issues start out being sort of complex, I thought I'd take a few minutes, if you'll indulge me, to describe exactly what the rules are that constrain us in coming out with our opinion. First of all, the zoning hearing board is not a free agent, not free to go any way it wants to just for the fun of it. It has some discretion, but basically it's bound by the record and the law. The two salient things that we have to work with are, first of all, the zoning ordinance, of course, and secondly, the precise language of the enforcement notice. We can't really go beyond those things. So what's before us is starting out with the zoning ordinance. The important parts of the zoning ordinance are there are two discrete uses that are relevant to our inquiry. One is called park and recreation, a use that's permitted by right, universally almost through the whole township, and certainly in the R3 district. That means that the person who wants to do this would have the right to go to the zoning officer, apply for a permit where it's needed, and go ahead and use that without any assistance from the board. The second use is the commercial recreation use. And commercial recreation, under the terms of your ordinance, is defined as a three-legged stool. There are three elements to it. So, and that is permitted in the village, in the Ludwig's district and the planned commercial industrial district. But and permitted as a conditional use, not as a matter of right. So any recreational use then becomes permitted unless it falls into the ambit of the definition of commercial recreation. And that commercial recreation has to have three elements, and they're written in the conjunctive and not in the alternative. In other words, and, all three have to be there. They are that it's operated as a business, open to the public, and for a fee. If one of those elements is missing, it then is not a commercial recreation use, but falls into the general definition of park and recreation. So you can see the difference. Park and recreation is permitted almost everywhere. Commercial recreation is permitted only in those two districts as a discrete use. They're not the same, they're two entirely different uses. And what had happened here was there were two uses attempted to be placed on the Dewey property. One, the park and recreation use, which was the exercise obstacle course kind of thing without more. And the other, to the extent that the three elements or the three legs of the stool are all present, then they tried to put in a second commercial recreation use. So the board had to look and see what was there as a lawful nonconformity because it existed before the proposed change of zoning, and what was there as a second use. The second use then is what we had to look at. I don't think anybody disputed on the record that the general use was a recreational use without more and was permitted. And that was before you tried to superimpose the second use, which is the commercial recreation. So the board had to analyze, to a certain extent, what the nature of the use was. Well, there were two enforcement notices. The first enforcement notice was never appealed and can't be collaterally attacked unless there is a change in circumstance. And when we read the record, we find that there was nothing there that made the second use much different from the first use. Therefore, the same finding would apply because the same use was really made of the property at both of those events. So we were bound by the results of the original enforcement notice, whether or not there was an appeal from the second notice. And the interesting aspect, you heard a lot of testimony, a lot of argument about whether the second appeal was timely filed. Well, frankly, the interesting part about that was we spent a lot of time doing research and could find no case on point, not only in Pennsylvania, but any place in the country. So we decided the prudent thing to do would be to decide on the assumption, A, that the appeal was timely, and B, that it was not. And interestingly, you come up with exactly the same result. It doesn't matter. Because since the second notice was based upon the first one, and the first one can't be collaterally attacked because it's binding without a change in circumstance, you come up with exactly the same results, that there has to be, the first one has to be enforced. So we don't care whether the appeal was timely or not because it doesn't affect the overall decision. I know I'm going fast here. If you understand what I'm saying, that surprises me because I'm not sure I do, but if you have questions, I want you to raise your hand because I don't want anybody to walk out of here not knowing exactly what we're talking about. Now, starting with that proposition then, we found that there's ample evidence in the record, and we're bound by the record, that there's ample evidence in the record to show that the second use that triggered the second notice of violation was substantially the same as the first one. There were no undue circumstances that give a reason to change it, and therefore you come up with the result that the board found that the second use is not permitted on this property. The first use may continue. And it is that, in that realm, if you understand that really what we're talking about is that the first use can continue unabated, it's never really been challenged. It is a recreational use, and it started in 2014 when they started to build the obstacle course. And that was fine. The activities were found to be of a commercial recreational nature, and we looked at that and we look at the zoning ordinance, and the commercial recreational use is simply not permitted in the zoning district. So the order we're kind of driven there with not much discretion about what we're going. Now, there are other things that are still hanging loose. We really haven't even gotten into the issue of the building permit, whether one was required, whether it can be issued and so forth. That's really a separate appeal. And what we're talking about here are the zoning application dealing with the enforcement notice. And the enforcement notice, the first enforcement notice, December enforcement notice remains in full force and effect, and it, not only by itself, but by the wording of the zoning ordinance, would bar a commercial recreational use. And therefore, when the applicant would hold a subsequent event, you would have to look to see whether that event, A, was for profit, operated as a business, open to the public, element 2, and for a fee, element 3. If any one of those three are missing, then you're back to a definition merely of a recreational use, which is permitted by right. Are we all equally confused now, or do we understand this? Because I don't want anybody walking out saying, what did he say? Based upon that, collaborating with Jim and with the assistance of one of my law students who also helped with the drafting, I prepared and Jim edited a proposed form of order. This was distributed to the members of the board to read and tell us if they had any comments or anything they were not comfortable with, so that we could make the changes that were necessary. I would point out, incidentally, before we get to taking the motion, that this is a public meeting, not a public hearing, and therefore it required one advertisement in the Pottstown Mercury, and the hearing was duly advertised according to law, and therefore is a proper meeting to hold. And I'd like that to be noted in the minutes of the secretary. That being said, the board has looked at the opinion, and I will turn the matter back to the chair.
Thank you, Mr. Agolnik. At this point, as Mr. Agolnik has explained, this board is prepared, I believe, to offer a motion. Yes, Mr. Frame?
I move that we deny the appeal for the reasons set forth in the draft opinion.
At that point in time, are there any changes or additions to that motion provided by Mr. Frame? If not, I would call for a vote. All I'm getting need a second.
I second.
Thank you very much. At this point, we'll call for a vote. All in favor of that motion, please answer with aye.
Aye.
I heard 5 ayes. That's a unanimous decision.
Now,
Motion is passed.
I'm gonna pass along the copy that's gonna be the one that we're gonna hand to the township manager, sitting right here. And we'll sign that. And if any of the attorneys or people who are parties want one that's signed, you can have one that's signed, or I have for you an unsigned copy. I just need you to come up and sign a little receipt so I know who I gave them to. And Susan, I see you first, and you're on the top, so you want, you don't need